Just because the state failed don't mean that she's innocent. Just because the state failed don't mean that she's innocent. Honey, I didn't want to play this video, but I'm going to play it. But I'm not like how she's talking. I'm going to keep it real. I'm not like how she's talking, y'all. Honey, you smell that? I smell some fraud going on. I smell somebody getting paid off going on. I smell something is funky going on with the Romeca case, y'all. The case has been compromised. Now, in this video, looking at these notes, I can tell y'all before I play, somebody is dead, which is Romeca, a mother. And let's not forget about that. So why are we trying to make this a whole sympathy story? That's what I want to know. Okay, anybody with me? Press one if you with me and put them pink hearts for Romeca. Look, they keep making Holly sound like the victim. I don't like this about this video. And I'm not buying none of that. Do you hear what I'm saying? They highlighting her, not what she did. Keep the focus on what she did. She killed a mother, okay? Outside of the schoolhouse, when she's going dropping off her kid. She did it outside there. She don't even live in that county. She lives all the way up somewhere, hours. She went down there by Romeca school where she dropped her son off and unalive Romeca. Okay, let's not forget about that. Okay, they said just because the state failed doesn't mean that Holly is innocent. That paperwork, that ain't truth. That's all we gotta say about this. And this don't feel like no clean self-defense. It don't feel like self-defense at all. We already know how many times did she shoot her and she shot her in the face. Listen, I'm going to play this video. I want to know what y'all thoughts about this. And we got to continue to talk about this, y'all, because I'm not liking what I'm hearing. And if y'all want to go live about this, press 7 if you want to go live. And we will go live this weekend. All right. So let me play here to see what this lady has to say. Tia. Girl, I'm too through with her. Let's go.
There is a website that you can go to. I think it's illinoiscourt.gov. You can see public documents. But then there's another website called, hold on, I want to make sure I'm giving you the right information. So anybody on here that wanted to look up court documents, you can go look it up. And it's researchil.com. That's not, I'm not telling you anything that's private information. This is in the public sphere and you can go see it for yourself. So real quick, because people have tried to say that I'm, in support of one versus another. That's not the case here, but I want to give you what is a win for Ari Williams, which is Quadeja Holly Johnson's attorney. This is a win for her because she has been essentially pleading with the court that her client, Quadeja Holly Johnson, poses no immediate risk to the public and should not be held in jail while she goes back and forth to trial. She doesn't pose a risk. She had never been in trouble before, all of those things. People that know Quadeja Holly Johnson have echoed the same thing online. So this is a win for her attorney. So when it came down to this appeal in a 2-1 decision, the court reversed the prior ruling, which was on a lower court's level, and remanded the matter of detention to the lower court for further proceedings. So let me explain what that means. And let me be very clear. I am not a lawyer, but I've covered enough to where I understand, legalese and legal process. So essentially what that means is this appeals court, 2 of the judges sided with Ari Williams and Quadeja Holly Johnson that she should not be held. One judge disagreed with them, but obviously it's 2-1. So 2 winning this. Right? 2 means that's more than 1. So then they prevail. Their say prevails in all of this. And so now what that means is it goes back to the lower court. The lower court is the court that she's currently going back and forth in and has been pleading this same situation. That court will now give the final say. So here's my take on this. As of right now, they're not supposed to be back in court until May. So I'm guessing this will be the first topic of discussion is, hey, will she be released? The judge would have to decide the reasoning of why not. Because at this point, a higher court has ruled that she should be released. All right. And let me read you some of this. some of what I have here. So, here's the opinion of the court, okay? And so there was 3 judges here. There was Justice Mikva delivered the judgment of the court with opinion. So there was an opinion from that judge on this case. Justice Odin Johnson concurred in the judgment and opinion. And then presiding Justice Mitchell dissented, with opinion. And they do note in here, because people will hear Odin Johnson, they may think there's some relation to Quadasia Holly Johnson. There's absolutely no relation. And they actually say that in the document, just so we're clear. So it goes on to say, defendant Quadasia Johnson appeals from the circuit court's order granting the state's petition to detain her before trial pursuant to, and then they give you a legal code, commonly known as the Pretrial Fairness Act. We reverse the circuit court's detention order and remand to the court to consider the conditions for Ms. Johnson's pretrial relief. In the petition for relief she filed in the circuit court, Ms. Johnson argued that the state failed to establish by clear and convincing evidence that the proof was evident or the presumption great that she committed first-degree murder, which is the detainable offense she was charged with, that she posed a real and present threat to individuals or the community, and that no conditions could mitigate that threat. We agree with Ms. Johnson that the state failed to carry its burden of showing that her release poses such a significant threat that she cannot be released pending trial with conditions. So again, this particular opinion is in the citing of Johnson and her attorney, saying that they do not believe that the circuit court has presented a clear argument of why she should be detained and not her trial. All right. Then it goes through the background, which we all know of what has been said and what has been found in discovery. According to the state, witnesses would describe how Mr. Smith stood between the women and pushed Ms. Johnson away from Ms. Blackmon, who was standing in the open driver's side of her door of her vehicle. The state reported that evidence would show that one witness called 911 to report a fight between 2 women and described as observing Mr. Smith repeatedly pushing the door of Mrs. Blackmon's car shut, hitting her with it. The witness testimony proffered by the state was that Ms. Blackmon then got into her vehicle and Ms. Johnson approached, threatening Ms. Blackmon. Ms. Blackmon got back out of the car and Mr. Smith placed her in a chokehold. Ms. Blackmon tried to break free. With her hand in the air, Ms. Johnson threatened to shoot Ms. Blackmon and retrieved a gun from her vehicle. Ms. Blackmon broke free from Mr. Smith and stepped backwards. According to the state's proffer, that was the point at which Ms. Johnson shot Ms. Blackmon several times. According to the state, one witness reported that after Ms. Johnson shot Ms. Blackmon, Ms. Johnson and Mr. Smith celebrated with a fist bump. Defense counsel argued that Ms. Blackmon was the aggressor and Ms. Johnson acted in self-defense. Hold on, pause that right quick. I'm going to go back to something, because I skipped over some at the beginning. I just want to make sure I didn't miss anything. So it's basically going into the facts of the case, everything that we know. Defense counsel argued that Ms. Blackmon was the aggressor and Ms. Johnson acted in self-defense. Defense counsel advised the circuit court that Ms. Johnson has sought a stalking no contact order against Ms. Blackmon December 2024 because Ms. Blackmon was repeatedly calling and text messaging her and her family members and commenting on her social media in a threatening manner. Defense counsel provided the state and the court with a transcript of a hearing held regarding that no contact order in June of 2025 and explained that Ms. Blackmon threatened Ms. Johnson directly by text until Ms. Johnson blocked her number, and then Ms. Blackmon sent threatening messages to others, including Ms. Johnson's grandmother, in which she said that she was going to kill Ms. Johnson. Ms. Blackmon was present at that June 2025 hearing on the no contact order, but did not make a subsequent appearance, and a default order of protection was issued on July 14th, 2025. Counsel for Ms. Johnson argued that the witnesses at the scene told police that after Ms. Blackmon got out of the headlock, she rushed as Mrs. Johnson's car with the 6-month-old baby inside, and that was when Ms. Johnson shot her. Defense counsel also argued that Ms. Blackmon had boxed in Miss Johnson's car by pulling up beside her when Mr. Smith's car was in front of hers, preventing her from leaving. On the issue of whether Miss Johnson posed a threat to the community, defense counsel emphasized that except for a speeding ticket and a misdemeanor retail theft conviction for which she received supervision, Miss Johnson had no criminal background. Miss Johnson had a valid FOID card and concealed carry license. She ran her own eyelash business, volunteered in the community, and had just been accepted into a program to become a dental assistant. Miss Johnson was also the mother of a young baby and had just become pregnant with the second child. Counsel underscored that Ms. Johnson had sought and obtained a protective order against Ms. Blackmon, that she stayed on the scene and waited for police, that she cooperated with them, and that the state waited almost 3 months or until December 3rd, 2024 to arrest her. The court granted the state's petition for pretrial detention. On December 22nd, 2025, Ms. Johnson filed a motion for relief pursuant to the Illinois Supreme Court Rule 604H. On January 7th of 2026, Ms. Johnson filed an amended motion. At the hearing on the motion, defense counsel provided the court with several exhibits, which are also part of the record on appeal. Defense counsel argued that the video footage showed that the state's witnesses could not have seen or heard as much of the incident as they claimed, and that particularly witness 3, who was the only witness to report the fist bump, was not in position to have seen Ms. Johnson after the shooting and did not report this alleged fist bump to the police when she spoke to them initially. Defense counsel also advised that the court that Mr. Smith had reported to the police that Ms. Blackmon approached Ms. Johnson, threatened her, and then swung at her. He also reported that Ms. Blackmon told Ms. Johnson, "I told you I was going to catch you," and that Ms. Johnson told Ms. Blackmon, "Leave me alone." Defense counsel pointed to video evidence that showed Ms. Johnson with her hair disheveled when police arrived on scene, looking as if she had been attacked. Hold on. I don't know if I have time to read all of this. I'm trying to skip around. Under the Pretrial Fairness Act, this is the analysis, all defendants shall be presumed eligible for pretrial release. Once the state has filed a petition, a defendant can be detained pending trial only where the state shows by clear and convincing evidence that the proof is evident of the presumption great that the defendant committed a qualifying offense based on the facts of the case. The defendant poses a real and present threat to safety of any person or persons of the community. No condition or combination of conditions provided in section 110 through 110B of the code can mitigate either the safety risk or the defendant's willful flight. All right, hold on. Go through this. I'm trying to get to the part. Hold on, you guys. We look next to the history and characteristics of Ms. Johnson herself. Her only criminal history is for a nonviolent misdemeanor. The state presented no evidence to suggest that Ms. Johnson has a mental health history, a social history that reflects a danger to the community. Ms. Johnson's physical condition is that she is pregnant. While her pregnancy certainly does not preclude violent actions on her part, its progression may well limit her ability to engage in them. Thus, for almost 3 months, she remained out of custody, but in touch with police as they continue to investigate this case. The fact also demonstrates that she had not posed then and likely will not pose if released a threat to the other witnesses involved in this case, as the circuit court suggested she might. We also find this to be a case where conditions could be imposed that will mitigate against any possible threat, and we remand to the circuit court for consideration of those conditions. Very significant to us is the fact that Ms. Johnson had both a FOID card and a concealed carry license for the gun that she used. This suggests that she would adhere to court order banning her possession of use of any firearms, which surely would be a condition of her release. For those defendants who have been arrested and are awaiting trial for offenses involving illegal gun possession, a ban on the possession of firearms is often viewed as an effectual condition of release. However, for Ms. Johnson, who appears from the record has never owned a gun illegally, this is a condition that could and should militate strongly against any threat. Finally, we note there is an additional consideration in this case, because if the detention order remains in place, Ms. Johnson could have to give birth while in jail. Before the Pretrial Fairness Act was enacted, a separate 2019 provision in the bail statute required a hearing before any pretrial defendant was required to give birth in custody. That provision currently provides that, quote, it is the policy of the state that a pretrial detainee shall not be required to deliver a child while in custody absent a finding by the court that continued pretrial custody is necessary to alleviate a real and present threat to the safety of any person or persons or the community. The trial court, citing this section of the statute, suggests that Ms. Johnson's pregnancy would require renewed consideration of whether Ms. Johnson should remain in custody as her due date approaches. However, for the reasons outlined above, we believe that Ms. Johnson should be released sooner rather than later to prepare for and give birth to her baby and prepare with her counsel for trial. Our dissenting colleagues suggest that we failed to appreciate the dangerous situation created by Ms. Johnson's firing shots on public street with children around when she shot Ms. Blackmon on September 8th of last year. Of course, we do, and that may well be an appropriate consideration at trial, but that is not the question now. So these judges are basically saying that's why the other judge is saying that she should stay in custody because she fired near a school. But these judges are saying they don't agree with that. Of course, we do, and that may well be an appropriate consideration at trial, but this is not the question now. Rather, the question under the Pretrial Fairness Act is whether Ms. Johnson will be such an ongoing threat to public safety that she must remain in custody while she awaits the trial. Trial will also be the right time to choose between the competing narratives of the confrontation between Ms. Johnson and Ms. Blackmon. The dissent paints, that's the other judge that did not agree with them, Ms. Johnson as the clear aggressor, motivated by jealousy or anger at a romantic rival, rather than by fear for herself and her 6-month-old child. We have briefly laid out some of the contrary evidence in our recitation of the facts, and we recognize that it will be up in the trier of fact, not us, to decide if this was murder or self-defense. So they're basically saying some of the facts in which the judge that does not agree with the majority is bringing up should be left to trial, not left to be a deciding factor on if Quadasia Johnson should be released. They believe that Quadasia Holly Johnson would pose no immediate threat to the public. A condition of her release, since she is a rightful gun owner and a FOIA card owner and concealed carry license owner, is that during her trial, she would not have access to any of those and access to her guns. But they believe, considering the fact that she assisted with the investigation for 3 months, she wasn't a flight risk, that there is no obvious, clear and present danger of why she would be a danger to the community, and she poses no flight risk. So it makes no sense, according to them, of why she shouldn't be released. So there you go. This is not an omission of her. This is not the judges saying that she's innocent. They're saying that anything about her innocence, whether she, this is an issue of jealousy, as the other judge who did not agree with them presented.